Oh my God, it's almost quitting time. 20 to 5. Okay.
2 more meetings.
Yeah,
I'm
2 more.
I'm already behind.
You're doing good. Minister of Justice, what's your name again?
Troy Lifford.
Oh, okay. So, I was very upset. I did a little video in Miramichi about this new proposed Bill 54, this law to give sheriff more power. And we've been talking about it for over 45 minutes. And what is really going to happen here?
Well, I think, Charles, we've spoke about this for a period of time now, and I think we've addressed and listened to many of the concerns that you've raised. And the intention here really is about to ensure public safety for everybody involved in the court system, whether it be the general public that's there to witness proceedings, someone that's there as a witness, the accused, the plaintiff, judges, court stenographers, sheriffs, enforcement officers, to ensure that the environment in the courthouse is a safe one for everybody to carry out the work. If somebody has acted in a threatening manner or has caused disturbances, that person may be denied entry to the courthouse based upon those actions. Currently, judges have the ability to do that. If someone acts up, they can have somebody ordered out of their court. And this is just extending that a little bit further to the courthouse itself, so that if somebody has been a threat, has indicated threatening actions towards some proceedings that are happening there that day, that they may be denied entry to the courthouse for those reasons.
Isn't it nice? I'm letting you talk and it's plain. That's good. It's a new proposed law. So, and what do we accomplish here at a meeting? Like suggestions, like can he be banned and wait 3 months for an answer, or he or she, or how?
Well, I think, on our end, this is a new piece of legislation.
Yeah.
And as with any piece of legislation, it's our duty to look at that and evaluate to see how it has been implemented. And, there's always a responsibility to review that and to see how it's worked, to see if there's changes that need to be made based on the way it's being implemented. So it's an onus upon us to do that reevaluation process. Something that's happening now, currently an individual can be denied entry into the court, and there's no mechanism for an appeal.
I know one person, yeah.
And that's something that we are bringing in to this legislation, is that if a person has been denied entry, there will be a mechanism for them to appeal that ruling. And I think it will be an onus upon us to endeavor to deal with those as efficiently and as possible.
And we're not denying people the right to appear in court or to watch our political system. No, that's inside the ledge. To watch our justice system at work. To somebody to be banned for 3 months, it has to be pretty extreme.
That's correct. I mean, if somebody is going to be denied entry into the court, they have to have done something to warrant that, such as causing outbursts, being a threat, not adhering to the rules of the building or of the court. That's what would lead something to be denied entrance to a court facility. If a person has been denied entrance and has legitimate business with the court, such as having to file documents, having to appear as a witness, then they will still be able to come into the court under the escort of a sheriff. So that business will still be able to continue.
And a person that has a mental problem, an attitude, voila, like me, can that person be looked differently if he or she has an attitude, or when he walks in and they say, I want to search you, and then you tell them to F themselves, oh, you're banned for 3 months. Can that work? Are you concerned about that?
Well, Charles, anybody that comes to a court facility has to go through a scanner, just like an airport-style scanner,
yep,
to ensure they're not trying to bring in something that could inflict harm on anybody in the building. If a person is not cooperative for whatever reason and won't go through a scanner, then that would be reason to deny them entry. If a person has nothing to worry about and goes through a scanner, no problems, then it wouldn't be an issue. But if a person refuses to do that, then that could be grounds for denying them entry.
If you're here in a year from now, with your assistant here, can we re-examine how many people were banned because of this new law?
It's something that's used very rarely now. We don't expect it to become a big issue going forward, but certainly I don't see why on an annual basis that we wouldn't track the number of people that were denied entry to a court facility, and that would be something that could be made available.
Thank you very much.